If you've been a victim of a crime, you're probably familiar with the criminal justice system, dealing with the police, the district attorney, and maybe even the criminal court system. Being a victim is bad enough, but if you've been injured, you may be entitled to compensation. Hiring a civil lawyer can help you begin that process. In a criminal trial, a jury determines whether someone is guilty of a crime. In order to find someone guilty, the law says the evidence must prove their guilt beyond a reasonable doubt. In other words, the jury must be convinced by the evidence almost to 100% certainty that the defendant is guilty of the crime charged. Civil cases are not only about proving fault, but also about proving damages, such as medical bills, lost wages, or pain and suffering. Because no one is charged with a crime in a civil case, the burden of proof is lower than it is in a criminal case. In a civil case, the burden of proof is known as a preponderance of the evidence, what is more likely than not. In other words, in a civil case, the jury must only be 51% certain that the plaintiff has proven his or her case. In addition, unlike most criminal cases, in a civil case, it is not necessary to prove a defendant intended to cause someone harm. In a civil case, a defendant may still be held responsible if they were negligent, if they simply weren't paying attention and caused someone harm. If you suffered physical or financial harm after a crime, even if you're not sure, we recommend that you contact a civil attorney as soon as possible. You only have a limited amount of time to file a claim, and if you don't act quickly, some evidence may be lost. You do not need to wait for the criminal case to end before you begin your civil case. Here at James Scott Farron, we have the technology, resources, and experience to help you with your civil case. There's a lot going on after you've been a victim of a crime. Give us a call so that we can help you through the process. We are here to help.